Hi, my name is Priscilla Hawks, and I'm the founder of Hawks Law Group PC. I want to thank you so much for joining me on today. So we've been talking about professional services agreements, and we're going to talk about common clause in this particular video known as breach. And a lot of people don't like to confront the idea of a breach because it just sounds like, oh, the sky is falling and lawsuits have to be involved. Unfortunately, that does happen sometimes, but in this section, look at it as a way to protect yourself. Hopefully you don't have to even confront it at all, and everybody does what they're supposed to do, and you have a seamless situation, event, or whatever. But in this section, you want to definitely include a couple of things. So the whole idea of a breach is that someone has not fulfilled their end of the bargain, hence the word breach. So what exactly does that look like? You want to put in your contract when breach occurs. If it's a situation where someone is supposed to work, for a certain number of hours or provide services for a certain number of hours, and they, try to leave early or whatever the case may be, is that a breach? Is it a breach when somebody does not pay the money when they're supposed to pay it? Maybe the contract says that there's 2 installments of $2,500 on specific dates, and the first installment was on time, but the second installment was not on time. Is that a breach? You want to make sure you're specific so that now the parties know when a breach occurs. However, the other thing you want to have in this section is whether or not you're going to allow an opportunity to cure. Sometimes you'll see clauses in contracts that talk about breach and what happens when there's a breach and when a breach occurs, but you really need to put whether or not there's an opportunity to cure, because it can really mess one of the parties up if that information is not there. For example, if you are a landlord of a building and you have in your leases that the rent is due on the 1st of the month, does that mean that if a tenant pays you on the 5th of the month, that now you can say that they breached and you can start eviction proceedings? You know what I mean? That sounds a bit unreasonable, right, to the average person. So that's why in this section, typically, if you're being fair, you're going to see some sort of language that talks about an opportunity to cure, or it says, even though there's a breach, maybe you have a grace period of 5 days or something like that. But this is the section where that language goes there. So you want to have what happens, or what does a breach look like, and then you want to have when exactly, if at all, you're allowing this opportunity to cure to take place. You want to also have in the agreement that just because you allow someone a grace period, or just because you allow someone an opportunity to cure, does not mean that you are waiving any rights you may have in equity or in law. And so what that means is a lot of times when a breach occurs, by default, there are certain rights that you have. You have the right, for example, to take somebody to small claims court. You have the right to file certain complaints or whatever. A lot of times, even if someone is willing to say, okay, you paid late, like we'll allow it this time, that doesn't mean that they want to waive all of their rights, in the future just because they kind of allowed you to be late this one time, or in default or in breach this one time. So in the breach section, a lot of times you will see that. Or if you're the person currently drafting, consider putting something about, not waiving any and all rights in the future just because you're giving this person a pass in this situation. All right, so breach is definitely one of those sections you want to consider having an attorney go over it with you, look it over, draft it for you preferably, and just make sure that your situation is well thought out and accounted for. But breach, one of the areas that you definitely will see in professional services agreements. Be creative, be very succinct with what you are attempting to put in there, and be clear. And I've find that a lot of times when people are just being reasonable, that this section does not have to be a nightmare. It doesn't require that it's like 2, 3, and 4 pages. A paragraph or so in many situations will suffice, and it's fair and it's clear, so you're all on the same page. All right, so breach, this is one of those sections you definitely will see, or if you're drafting, that you definitely want to put in professional services agreements. This is Priscilla Hawks coming to you in a New York Minute. Take care.